Hello, everybody. This is Stephen Long. I am the broker in charge of Keller Williams Realty Elite, as well as the education director for the Career Academy of Real Estate. I want to take some time to do a quick video on the current offer to purchase and contract, Form 2T. It has been brought to my attention that I haven't done one in a little while, so I wanted to run through that very quickly. This is not a how-to as far as the technology side, but moreover just a review of the offer to purchase and the terms that you feel comfortable filling those out. So I want to do a screen share here and show you how to do that very quickly. All right. So here is your offer to purchase and contract, the affectionately known as the Form 2T. And I did just want to take a minute to run through some of the paragraphs and clauses within this contract so that you guys are familiar, can explain it well to your clients. So paragraph 1, and actually before I even get started, let me remind you that the offer to purchase, the guide buyer agency agreement, and the listing agreement all have guidelines, and so you can find the guideline documents in your form software as well, and they also explain in a very good format how to and what each paragraph means. So if you want to read through those are a great explanation as well. So under the first section, you're going to talk about the terms and definitions. And so here we're going to define who is the contract with and what is it for. And so we have the seller and the buyer. The seller should be listed as the person on the deed. Typically, you want to pull a copy of the deed. You can go to the county's register of deeds and see who is on there, unless you have reason to believe otherwise, or if you've been instructed otherwise. In some cases, the seller may not even actually own the property yet, so they may not be on that deed. So that you want to verify who the seller is and get that correct. Likewise, you want to make sure you have your buyer's information in there so that we are very clear about who the buyer and seller are. The filling out the contract and making sure we're accurate is very important because this is a contract between the buyer and the seller. In the event that we botch this, they need the ability to pursue one another for breach of contract. So that if the seller breaches, the buyer has that ability. If the buyer breaches, the seller has that ability. If you fill out the contract wrong, you may compromise their ability to do that. So we do want to make sure we're very well versed in filling out the offer to purchase. Next, we want to define what is the contract for. In this case, is a purchase of real property, and we need to be very specific about that property, not just a street address. If we put just 123 Main Street, that could be multiple main streets across the country. We want to be as specific in this section as possible. So put the street address, the city, the county, and of course the zip code. Likewise, in the legal description, we want to be as specific as possible, including the lot number, block, if you can find it, the subdivision, plat book and or page if it has been platted. The parcel identification number is an excellent opportunity to fill that in. And then do please use this other description, for a house and 4 acres located on whatever road, the lot between this house and this house of approximately 0.5 acres. Of course, that would be on a vacant land contract, but you get the point. Be specific there as you can, so there's no question about that. And lastly, the deed book and page, which we will want to cross-reference the deed book and page. I don't recommend you just take the one that's in MLS because some listing agents get that wrong. So check the deed book and page to make sure you are referencing the right property. And again, that can be found at your county's Register of Deeds online lookup. So the purchase price is the amount being paid for the property. And that is the total purchase price. Remember, the due diligence is a non-refundable fee given from the buyer to the seller. At the time of contract, it is due the day this becomes an executed contract from the buyer to the seller. It can be paid in cash, personal check, wire transfer, official bank check, or you can use an electronic transfer service like even Venmo or something of that nature. We just need to indicate that what is being used here, and then likewise have a tracking mechanism so we can determine that it did get from buyer to seller as it should. If the buyer does not deliver to the seller on the effective date of this contract, the buyer could be in breach. And you'll learn later in this contract that if the buyer is in breach, then they are entitled to lose their earnest money and due diligence to the seller. So we do not want them to be in breach and deliver and have your clients prepared to deliver this due diligence the moment they go under contract. Now, this money is attributed to them at the time of the purchase if they purchase the property. If they do not purchase the property, they will lose this due diligence. It is very, very difficult to get due diligence back. The only way due diligence gets refunded is if we can somehow prove that the seller was in breach of contract. Not that the listing agent marketed it wrong or the listing firm did something wrong. That's the listing firm. This contract is between buyer and seller. So that due diligence fee goes to the seller, and the only way it comes back to the buyer is if they nicely agree, or if the seller can be found to be in breach, and that can be difficult to prove. So please explain that. If you have any questions about it, please make sure you get the question answer on due diligence brochure. It's in the you can find it on ncrec.gov, the Real Estate Commission's website, under publications. It's a great little thing to help explain due diligence and emphasize that the importance of understanding that. Now, earnest money is traditional. A lot of folks remember this. This is earnest money that is going to go into an escrow account. It will be held in escrow, which is a safe place to hold other people's money until we are either ready to close, and that is a credit to the buyer, or it could be refunded to the buyer if we terminate prior to the due diligence date. If we terminate after the due diligence date, this earnest money then would be released to the seller. So we need to make sure that we explain how that works. There's also a question answer brochure on earnest money and how that works, but you should be able to explain that well. Likewise, it can be delivered in the same format. If you check this box here, it is within 5 days of this contract. Notice due diligence does not have that 5-day window. It is due the day it becomes a contract. But we can check this box and get it to the escrow agent within 5 days. The delivery of the earnest money and or due diligence does not make or break a contract. Once it is signed, it is a contract, period. Whether the monies have been delivered, it is still an enforceable contract. Not delivering earnest money, not delivering due diligence fee would constitute a breach of contract. So it is a contract the day it is signed and becomes one. The exchange of monies here does not make or break this contract. If you want to do additional earnest money deposit, you can do that as well. And there's how it would be delivered. If you're going to do a loan assumption, you could put that in here. If you're going to do any seller financing, you would do that here and include the owner financing addendum, which is referenced there. Likewise, if you're doing a new construction or a building deposit in conjunction with a new construction, you would do that and add that addendum here. This number here should be the balance of all of the purchase price, less these numbers would go there. Now, remember, if they should fail to do so, they would, of course, be in breach. And that's what that goes on to say here, is that the due diligence is due at the time of contract and would be a breach if they do not deliver it. Same with earnest money deposit. It does have to be deposited within 3 days, or unless you check the box above saying 5. The escrow agent is who's going to hold it. Typically, this is going to be the closing attorney. Historically, the listing firm may have held the earnest money. They may still have some listing firms that hold that. I think Coldwell Banker, for example, locally is a firm that might still have a trust account, and they very well may still want to hold escrow. Find out if they do, but typically this will go to the closing attorney. Now, if there's no earnest money, zero earnest money, you don't have to put in this escrow agent. This is not always the closing attorney. This is just the person holding the earnest money. Anytime we hold money in trust, we have to let the parties who have an interest in it, both buyer and seller, know where it's being held. So that's why we have to fill that in as the escrow agent. Remember, effective date is the date that it becomes a contract. The due diligence is the time that the buyer is purchasing for that due diligence fee to do any and all inspections. And that period would end here under section I. You would put the date at 5 o'clock on that date. Notice time being of the essence. Due diligence ends. So that is the time that the buyer has to have everything done to be satisfactory that they can move forward towards closing. That includes their appraisal, their loan, their lending conditions, anything that they need to have resolved needs to be done by this time, the 5 o'clock on that due diligence. Otherwise, they risk losing their earnest money if they do not move forward with that transaction. Because if they terminate any time after 5 o'clock on the due diligence period, any earnest money on the table is now subject to being released to the seller. That's how due diligence works. Now, they could terminate for any or no reason at all throughout this contract. That's part of our deal. The buyer can terminate an hour before closing, no problem. We're just looking to determine, are they going to lose their earnest money, or are they in their due diligence period? If they're still within this due diligence period, the only thing they have lost is the due diligence fee. Settlement is the day what we're going to refer to the day everyone comes and closes. We call it closing. And closing is when we're actually on record, but settlement is the time in which everyone comes together and signs all the documents. That settlement date should be included here, and give yourself plenty of time to make sure that you can get on the books with an attorney. If there is a delay in settlement, note in this box, we'll see it here in just a minute, but that delay in settlement is now only 7 days. Some of you might be used to a 14-day delay. It is not. It is only 7 days. So remember, settlement is when everyone comes and signs. Closing is when the property is actually getting recorded. Until we have a recording, we don't have a closing. At the recording, the deed changes hands. Once the deed has changed hands and we are closed, that's when we have successfully completed our goal with this contract. Keep in mind that special assessments are, in fact, or maybe the responsibility of the buyer or seller, depending on whether they are pending or confirmed. Confirmed special assessments are going to be responsibility of the seller. Any pending or proposed special assessments, the buyer would inherit those expenses. So make sure you do your due diligence with your homeowners association, taxes, etc., to make sure that we're all on the same page with that. On paragraph 2, we're going to talk about fixtures and exclusions. Remember that fixtures are anything bolted, screwed, glued, attached, or in any way, shape, or form affixed to that property in a way that they should not be removed, or they would do damage if they were removed. It goes so far as to bullet point, excuse me, a large chunk of the commonly referenced fixtures. So these are all, and remember, fixtures stay 100% unless we exclude them. And we'll talk about that here in just a minute. But there's a lot of things, including the TV mount. The TV mount is a fixture because it is bolted to the wall. The TV on the mount is personal property. So have conversations, negotiate these out. Vanity mailboxes, like the catfish mailboxes, those are going to be fixtures unless otherwise negotiated. So make sure you're addressing with mirrors, cabinets, and doors, and all bathroom wall mirrors are going to be fixtures. So be careful to watch those things. We now have this new paragraph of unpairing devices. So if you have smart devices in your home, Nest thermostats, security cameras, etc., please make sure that they understand contractually they are obligated to unpair them, meaning they can no longer monitor the people in their new house after they move in. That's just creepy. So unpairing those devices is a requisite per the contract. Now, you do have some items that might be leased or not owned. For example, and it does give you a few, fuel tanks being one of them. A lot of people have a propane gas tank that is often leased from the gas company. So make sure we address what is leased and not owned. They may very well own the tank and therefore the fuel in it. So we want to make sure we exclude or include those items here. In paragraph E, we're looking at items that would not convey. So the following items shall not convey, meaning that they are going to be taking with the seller. So if there's a fixture here that the seller intends to take, make sure it is itemized clearly and conspicuously in this paragraph. Otherwise, if the seller takes a fixture, they would be responsible for replacing it or putting something of equal or greater value back. So make sure that if there's anything that is a fixture, glued, screwed, attached, bolt to the property, flowers, bushes, hydrangeas, roses, all fixtures. So if they're going to take any of that, they need to make sure that they exclude it here and know that any damage is done as a part of that removal, they will, of course, repair. Now, personal property is where we would list any personal property that would transfer with this. Now, you'll notice that some of the most common items here are things like a refrigerator. A refrigerator is typically personal property unless it is actually built into the kitchen. If you have one of those fancy refrigerators that kind of has the cabinet doors on it that match all the cabinets around it, that's considered a fixture. That is built into and designed for that space. If you just have a freestanding refrigerator, that is something you may want to include as a part of the negotiations in your personal property requests. So these are the things that would be left. Keep in mind they are at no value. So a lender does not want to see the couch and chairs and all the furniture in the house because they don't want to mortgage furniture for 30 years. So if you're getting a loan, please keep in mind they probably do not want a laundry list of personal property here, but typically we can get away with something like a washer, dryer, or refrigerator. So make sure you keep an eye on your personal property negotiations as well. As always, the buyer does have their due diligence process and they are encouraged to do so. They do not have to. They can do no inspections at all. They don't have to do anything, but they should do any and all inspections that they feel are pertinent to making sure they're comfortable with moving forward in the purchase of their house. That does include their loan, their appraisal, anything that is required for the lender, finding out, if you're doing manufactured, find out the HUD information or whether the title's been relinquished, back taxes, whatever is of importance to your buyer, they need to figure this out during their due diligence. That includes, of course, things like their typical home inspection, radon inspection, moisture inspections, all the radon is a popular one. So make sure they get all those done. Also, they need to review any restrictive covenants and bylaws. If they're in an area that might have those, they want to read those. As brokers, we cannot interpret them. If they say, can I put up a fence? We're not going to look up the HOA restrictions and be like, yes, it says you can. We're going to give them a copy of the HOA restrictions, and we're going to send them to an attorney to make sure that they can do what they want to do. We're not, HOA documents and restrictions are legal documents, and we're not trained to interpret legal documents beyond that of our standard forms. Likewise, insurance availability, something that as simple as a flood insurance, whether we're in a floodplain, you can get a clue report from the insurance agent at the time of going under contract to determine if this house has ever been burned, flooded, damaged, had a claim. Otherwise, it may prevent it from being insured. That's something you want to do during your due diligence period. Appraisals, survey, check your zoning, make sure it's going to work for your use, flood insurance, utilities access, make sure you can get the internet that you need if that is something that you require, as most of us do these days. Streets and roads, this is a big one, making sure that you understand whether the street or road is private. You should not rely on the listing agent in that capacity. You need to verify with the Department of Transportation, is this a public road? Is this a private road? Who is responsible for maintaining this road? Are there any special assessments from any governments or HOAs, local municipalities or HOAs in that area? Likewise, let's deal with that fuel tank one more time and make sure that there are any there, whether it be above ground, below ground, in the house, outside the house. What is it? Where is it? And does it go? Does it stay? What does it contain? Is it leaking? Those are all things we want to look for. If the property is up for sale and there's an existing lease, that's something that we need to address. Remember, leases, anything that is being rented, most leases have to be honored by the new buyer. So if it is being rented, the new buyer will inherit that lease and that tenant unless otherwise negotiated. So please address that situation on the front side of this contract, so that your buyer may not inherit a tenant that they do not want. Remember, all houses in North Carolina is capital bold, sold as is, where is in its current condition. We don't need to repeat it. It says it right there. All houses are being sold as is, where is. If we are going to request repairs, it is simply that, a request to the seller for repairs. They have no obligation to do any of them. The seller doesn't have to fix anything. Even if your lender says that has to be fixed, the seller doesn't have to fix anything. Could they? Sure. Could we ask them nicely? Absolutely. Will they? Probably not in this market. So please be sure you address that, because if there are lender required repairs, the seller doesn't have to do it, and the seller doesn't have to allow the buyer to do it. So the buyer, even though they might be willing to fix it themselves or repair it on their own expense for their lender, the seller doesn't have to allow that. And so therefore we need to make sure we have these things worked out within our due diligence period. If in fact the buyer does any of these inspections and they damage the property, they punch a hole in a wall, anything like that, they're going to be responsible for putting it back in its current condition. Now, if there's something wrong, like for example, the floor joist is rotted and you didn't know that, and you walk through and the floor joist breaks, that's not your responsibility. That damage had already occurred. In the event that's the situation, that's not a buyer repair responsibility. But if your home inspector, for example, steps off the truss in the attic and puts his foot through the ceiling, then the buyer and or home inspector are going to be liable to repair it back to its original condition. There's an indemnity clause here so that you hold each other in indemnity and not sue each other. There's also the right to terminate, which of course is into the contract, but we want to make sure we're doing so probably during that due diligence period. But please remind them it can be terminated up at any time, all the way till closing. And I have had contracts terminate the day of closing. It's just a matter of whether the sole and exclusive remedy in this case to the seller is due diligence and earnest money. Nobody's suing anybody. On paragraph 5, we have buyer representations, where the funds to complete the purchase, in this case, if you're buying cash, is or is not attached. So if you're buying cash, you check this box, and you either have or have not attached those proof of funds. If in fact you need to procure a loan, you check this box, and you're going to disclose your intents on how you intend to fund it. Now, remember, this is a disclosure of how the buyer intends to fund it. If they wanted to go from a FHA to a conventional loan, they can certainly do that and it not be a breach of contract. Also remember, if they're going to go from conventional to FHA or VA, there is that FHA or VA addendum, but after we're under contract, the seller is not obligated to sign the FHA or VA addendum, thereby making it more difficult on the buyer, possibly impossible for them to get the financing they need. So if they intend to try to go under contract as cash and or switch to FHA or conventional and switch to FHA or VA, you need to advise them that that may not be a good idea, because they could in fact find themselves in breach of contract if they can't get the seller to sign those forms, or having to terminate, at least, not necessarily a breach. Also, don't enter into a contract under false pretenses where you're disclosing I'm going to pay cash, but you're not. You can certainly switch from cash to a loan within your prerogative, but remember, you're bound by the terms of this contract, meaning you have to pay the purchase price in the timeline in which you said. If you switch from cash to a loan in this process, you may not have the requisite time to get the appraisal and all the things done that need to be done to meet your obligations to the contract, but it's in that buyer's prerogative to do so. See, if paragraph B, if we have another property to sell in order to purchase, we're going to disclose that here. And then so answering the following questions with whether it is listed or will be listed. Under paragraph D, we're talking about the property owner disclosure statement where we will say we have received or have not received, or it is exempt. If you're exempt, you can check the guidelines documents, but things like foreclosures and new construction are exempt from the residential property owner disclosure statement. Meanwhile, the mineral oil and gas rights doesn't really have a lot of exemptions. So we want to check that to make sure that the buyer has received them or has not received them. There are a few cases where it is exempt. For example, vacant land does not require mineral oil and gas rights, but that would be a different contract. Your buyer's obligations, again, you're responsible for special assessments. You're going to be responsible for your typical buyer paid closing or buyer paid costs like your appraisal, your title search, or any attorney fees and recording the deed. So these are all some things that the buyers are basically agreeing that are going to be their responsibility from a cost perspective. You are also checking the box to disclose your information. So the buyer authorizes the buyer's lender and parties to share the information as needed with the attorney and their agents to make the transaction happen. It's not anything confidential, but it allows us to communicate with each other through the transaction and get everything dispersed and closed as it should. Now, paragraph 7, we flip over to the seller side. The seller has a few obligations here, not a lot, but a few. One, they're going to disclose how long they've owned the property, less than a year, more than a year, or don't yet own the property. Lead-based paint, whether it was built prior to 78, and we'll attach that addendum if it was. Is there a homeowner association? And if so, these are things that the buyer may want to check out, and we can ask the seller to procure them as well. But the buyer would want to verify all these things prior to purchasing. This is where hopefully the seller can provide us that information. Likewise, the seller does have to provide evidence of good title. They are giving you the authorization to share with their agent, just as the buyer did, to communicate with the attorneys and lenders to get a closing done. They have to provide access to the property. That's a big one we run into these days. The buyer has the right to do any and all inspections, and the seller needs to know they are agreeing contractually to allow the buyer the access they need to do their inspections. Now, if something happens with where the existing utilities and things like that need to be cut on, these are the responsibilities of the seller as well. So they need to have on propane gas. If we need to inspect the gas logs, they need to have on electric, they need to have on water. So all those things can be done as a part of the seller's responsibility unless otherwise agreed upon in this contract. Removal of the seller's property, meaning they got to get all their stuff out clean and free of garbage and debris. This does not mean spotless carpet cleans and professionally done. This means essentially broom swept. Have everything out of it. Is it going to be perfectly clean? Who knows? Everyone's definition of clean is different. Prepare your buyer, prepare your seller, but we do need to get them to have their stuff and their garbage and debris off the property at a minimum. There's an affidavit of indemnification, basically saying they are the seller and they are going to indemnify and not sue anybody in that capacity for in conjunction with this relationship beyond what is addressed as a remedy in the contract. Designation of a lien agent as needed for certain appointments. If there is one, for example, new construction things have to have designation of a lien agent. They have to provide good title, and it does say we're going to provide a general warranty deed to that buyer. If that is not the case, if this is a foreclosure, we might need to fix that, or it might have to have an addendum that says we're getting a special warranty deed or an attorney's deed. There might be a different type of deed. Generally, we want to have that general warranty deed as the blue ribbon prize. If that is not the case, we may need to edit that. On paragraph H, this is where we're going to talk about the deed to be made to, and that is the person who the deed will be made to. I often get the question, hey, the buyer is X and they want to have the deed made to X, to Y. Can they do that? Absolutely. A person purchasing a property can deed it to whomever they like. Whether the lender has issue or not with it is another story. But for example, if I'm paying cash, I could buy a house and deed it to my son, my sister, whomever I like. So on section I, this is where we're asking for the seller to contribute X number of dollars here towards the buyer's expenses. Don't let the buyers and sellers get confused. Mr. Seller, you still have your own expenses, including commission, attorney fee, deed prep, excise tax, all those things. In addition to that, the buyer is asking in conjunction with this contract for you to pay X number of dollars, let's say $5,000 towards their expenses also. So for example, if you're offering 100, if the purchase price is 100,000, you would get 100,000 and you're going to pay 5,000 of their closing costs, meaning you would only gross that $95,000 as a seller. And from that $95,000, you also have to pay your expenses, including commission, etc. So I have had sellers get confused thinking this is the only expenses they would be paying. That is not the case. This is in addition to their normal expenses as a seller. Of course, there's owner association fees. If any of that is charged, we need to get those paid for and procure those documents. If there's any special assessments, that's going to be paid for by the seller, of course. Negotiated repairs need to be done in a good workmanlike manner prior to close, not to the expiration of due diligence, but remember, prior to closing, meaning the buyer should reinspect as well any repairs that are agreed upon before closing to make sure they are done so in a good workmanlike manner. And they should verify this prior to settlement or closing. Does not mean it has to be done prior to the due diligence period. That's a common misconception. You have to agree upon it and have the agreement executed prior to the due diligence, preferably. And then they are obligated to get those repairs done as the seller prior to closing in time for the buyer to reinspect to be satisfied to go to closing. This is where if the seller's breach of contract occurs, we need to read that paragraph 23, which will talk about the remedies afforded to a buyer in the event of a seller's breach. Essentially, the seller would have to refund the due diligence, earnest money, and any damages the buyer has incurred to get to this point. We want the buyer to be set whole and reimbursed for any of their expenses, which is why we need to encourage the seller to not breach at all. So make sure you review what their obligations are so they're not breaching contract. Remember, prorations and adjustments from pre-license class, that's no longer your responsibility because you don't have to do that. The closing attorney will, but we are also responsible for the accuracy of that. So we should double check to make sure that things like taxes, rents, HOA fees are all being prorated appropriately. If there's going to be a home warranty negotiated into the transaction, there are 3 boxes here. One says none to be done to be provided by the seller, or the buyer may obtain one and the seller agrees to pay for it at X number of dollars, or the seller has already obtained one from this place and will pay X number of dollars at closing for it. Risk of loss or condition, paragraph 11 basically says if the house burns down while we're under contract, the seller is obligated to give the buyer the option of receiving the insurance money to rebuild it, or the buyer could essentially terminate the contract without penalty and being reimbursed because the sale could not consummate as planned. Paragraph 12, this is what I was talking about with the delay of settlement. Notice now that it is a 7-day delay. It used to be 14 days. If we can't hit our closing date as indicated back on page 2, then we only have 7 days for the delaying party to fix whatever they need to fix. Now, mind you, it says 7 calendar days. So that's really only 5 working days typically. So if you need to deal with a bank or an attorney or something of that nature, you have a very short window to cure this. Otherwise, beyond that 7 days, the delaying party is in breach, meaning that the non-delaying party can then terminate that contract and move on. So if it is the buyer who cannot close, the seller can terminate that contract, keep their due diligence, keep their earnest money, put it back on the market and move on. But we do have that 7-day. Please remind buyers and sellers, closing is a target, not a drop dead date. We have a little leeway up to 7 days that we can make this work. So if you have to be somewhere, have a backup plan. Always have a backup plan as a buyer and a seller because it may not happen on that day, especially in today's world. Possession does not happen until we are on record. Once we have the deed recorded, the buyer can take possession. If anything different is going to happen, we have an addendum for that. So you have the buyer possession before closing or a seller possession after closing, or there may be a tenant. Either way, we try to avoid all 3 of those if we can. But if you're going to use them, please read those and apply them appropriately. But typically buyer possession and seller possession should be used for a very short term, if at all. Your other pre-populated addenda that exist in your form software are listed here that you may opt to use. Common ones include the FHA and VA financing addendum, the lead-based paint addendum. There's also oftentimes an additional provisions as well. So these are some of the most common. Of course, there are several, and you should look at those as well. You can find them in your form software. Buyer and seller may opt to have one drafted by an attorney as well. Remember, buyer or seller can actually draft their own addendum. They do not need an attorney to do it, but as brokers, we need to, in writing, let them know that we as brokers, of course, cannot draft anything and write anything here. And they as buyers and sellers, unless they are an attorney, probably should not either. because it is difficult when it comes to push comes to shove and we have to enforce something. If it's not written in what I call legalese by an attorney, it may be very well difficult to enforce. So if there's anything that doesn't fit in one of our pre-populated addenda and we need to have something added, it's probably a good idea to have an attorney draft it, check that box and say see attached. Now that is not an expensive process, so don't be afraid to reach out to your attorneys and get whatever unique terms you need drafted. Paragraph 15 explicitly states this contract is not assignable. In the world we live in, a lot of people want to use a signed contract or assign. That's awesome. They just can't use this one because this is not an assignable contract. On paragraph 16, and we're talking about a tax deferred exchange, if the buyer is or the seller is using any kind of 1031 exchange, please make sure you get some additional training on that. Ask those questions because that requires additional work on the broker's part to inform the attorney, get in contact with the 1031 exchange company to make sure that all flows accordingly. But there could be a tax deferred exchange in there as well. There's whole classes on that. Paragraph 17 identifies that the parties are the buyer and seller, and that's who this contract is between. If buyer or seller should pass, this estate will go on, or this contract will go on to their heirs and their estate. Which is what paragraph 18 says in regards to survival. Under paragraph 19, that says we've gone over the entire agreement. There's no hidden deals, no other handshakes or agreements. It's all agreed upon here in writing. We'll agree to conduct the transaction as typical as possible. Execution means that this is the only version of this contract. If there are identical versions of this contract signed by different parties, meaning we could have this contract signed by the buyer, this contract signed by the seller, the exact same contract, because they are mirror images of each other, together they constitute one instrument. That typically doesn't happen in this world because we have electronic signatures, but that is certainly a clause in the contract. Computation of days, again, we're in the real world. We're prorated on 365 days a year. If it's a leap year, it's 366 days a year. And of course, we want to make sure that all things are done so. All right, remedies. This is the important part for a breach. In the event of a buyer breach, if the buyer breaches this contract, the seller has the ability to keep their due diligence and earnest money. It basically states that due diligence and earnest money are the entire remedy to a seller in the event of a buyer breach. So if they don't deliver the due diligence money, the buyer breaches, the earnest money and due diligence go to seller. If they walk away the day of closing, the sole and exclusive remedy to the seller is that due diligence and earnest money. They're going to want to call an attorney. They're going to want to sue. They're going to get mad because they do. That due diligence and earnest money is important. Everybody's like, earnest money is no big deal. Well, earnest money is a big deal when they've passed their due diligence date and they close an hour before closing, or they terminate an hour before closing, and the only thing they've lost is their due diligence money. So earnest money is also important. Now, breach by seller is difficult to prove, but in the event that a seller does breach this contract, the buyer can receive compensatory damages, including due diligence, earnest money refunded to them, and the cost of anything related to this transaction that cost them money to this point. They could also pursue or talk to an attorney about the possibility of suing for specific performance, but that is also a challenge. Attorney's fees are basically going to be respective of the buyer and seller. Typically, the buyer is going to pay most of the attorney fees for the closing. The seller will also have to pay for their seller docs, which are the new deed, lien waiver, and owner occupancy affidavit. So those types of documents are a seller expense, usually running not nearly as much as the buyer would pay for their closing attorney. So just noting that that is how that works out. And as always, we're not attorneys and we are not allowed to do any of the attorney things except fill out our standard forms. Please don't skip the red box, the wire fraud addendum. Please make sure you circle, star, underline. You may even want to have them initial this box because wire fraud is continuing to be a big issue in our industry, where we are moving large amounts of money in due diligence and earnest money. And in email hijacking of some wiring instructions can lose that money forever. And if you haven't documented where you clearly explain that you would not allow this to happen, or that you will not be asking for the information that is requisite to make this happen, they need to pick up the phone, they need to verify directly, they need to take precautions with the attorney, the buyer, the seller. Use caution, use caution, use caution. So that's a big thing in wire fraud. Here you'll fill out the names of the seller, the buyer, and the listing firm and the buyer firm, and your respective agency situations. Lastly, on the, I guess it's page 15 now, we have the signature for receipt of monies, both the due diligence and earnest money. Sometimes due diligence is sent directly to the seller. So the seller then would just sign here. We don't need the listing agent to sign that they received it because they never did. It went straight to the seller. That's what we're looking for, to make sure that it reaches its final destination. Likewise, we want to make sure that earnest money reaches its escrow destination as well. And with that being said, I believe that wraps up my conversation with the offer to purchase and contract. I hope you found this helpful. If you have any questions, feel free to reach out to me. I'm happy to answer and be of assistance to you guys. I do recommend that if you've not done a contract and offer to purchase yet, you practice. I would fill one out for your buyer or for yourself or a spouse or a friend. Pick out a property, pick out the property you live in, and write an offer on it just to get familiar with the process so that you're not practicing your first transaction on the consumer. And when you get to that point in your career, you are well poised to do a great job with that. So I hope this has been helpful. If you get anything, you guys know how to reach me, and please have a great day. Thanks so much.